Members of the jury, the court will now instruct you in the principles of law which you are to follow in considering the evidence and in reaching your verdict. It is your duty to follow all of these instructions. Regardless of any opinion you may have about what the law is or ought to be, you must base your verdict on the law I give you in these instructions. Apply the law to the facts in the case, which have been properly proven by the evidence. Consider only the evidence received during this trial and the law is given to you by these instructions. And from these alone, guided by your soundest reason and best judgment, reach your verdict. If any member of the jury has an impression of my opinion as to whether the defendant is guilty or not guilty, disregard that impression entirely and decide the issues of fact solely as you view the evidence. You, the jury, are the sole judges of the facts, and the court is the judge of the law only. The first count of the information charges that on or about Tuesday, April 4th, 2017, in the town of Janesville, Rock County, Wisconsin, Joseph A. Jakubowski did intentionally enter a building without the consent of the person in lawful possession of the place and with intent to steal, and armed himself with a dangerous weapon, to wit, a firearm, while in the burglarized enclosure, contrary to section 943.10 sub 2 sub b and 939.50 sub 3 sub e of the Wisconsin statutes. To this charge, the defendant has entered a plea of not guilty, which means the state must prove every element of the offense charge beyond a reasonable doubt. The second count of the information charges that on or about Tuesday, April 4th, 2017, in the town of Janesville, Rock County, Wisconsin, Joseph A. Jakubowski did intentionally take and carry away movable property of Armageddon Supplies, which property is a firearm, without consent and with intent to permanently deprive the owner of the possession of the property, contrary to section 943.20 sub 1 sub e and sub 3 sub d and 939.50 sub 3 sub h of the Wisconsin statutes. To this charge, the defendant has also entered a plea of not guilty, which means the state must prove every element of the offense charge beyond a reasonable doubt. The third count of the information charges that on or about Tuesday, April 4th, 2017, in the town of Janesville, Rock County, Wisconsin, Joseph A. Jakubowski did have in his personal possession a hammer for use in breaking into a building and with intent to use such hammer to break into the building and to steal therefrom, contrary to section 943.12 and 939.50 sub 3 sub I of the Wisconsin statutes. To this charge, the defendant has also entered a plea of not guilty, which means the state must prove every element of the offense charge beyond a reasonable doubt. Evidence is first the sworn testimony of witnesses, both on direct and cross-examination, regardless of who called the witness. Second, the exhibits the court has received, whether or not an exhibit goes to the jury room. Third, any facts to which the lawyers have agreed or stipulated, which the court has directed you to find. Anything you may have seen or heard outside the courtroom is not evidence. You are to decide the case solely on the evidence offered and received at trial. And information is nothing more than a written, formal accusation against the defendant charging the commission of one or more criminal acts. You are not to consider it as evidence against the defendant in any way. It does not raise any inference of guilt. Disregard entirely any questions the court did not allow to be answered. Do not guess what the witness's answer might have been. If the question itself suggested that certain information might be true, ignore the suggestion and do not consider it as evidence. Attorneys for each side have the right and in fact the duty to object to what they consider are improper questions asked of witnesses and to the admission of other evidence which they believe is not properly admissible. You should not draw any conclusion from the fact an objection was made. By allowing testimony or other evidence to be received over the objection of counsel, the court is not indicating any opinion about the evidence. You jurors are the sole judges of the credibility of the witnesses and of the weight of the evidence. An exhibit becomes evidence only when received by the court. An exhibit marked for identification and not received is not evidence. An exhibit received is evidence whether or not it goes to the jury room. Remarks of the attorneys are not evidence. If the remarks suggested certain facts not in evidence, disregard the suggestion. Consider carefully the closing argument of the attorneys, but their arguments and conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence under the instructions given you by the court. The weight of evidence does not depend on the number of witnesses or on each side. You may find that the testimony of one witness is entitled to greater weight than that of another witness or even of several other witnesses. In weighing the evidence, you may take into account matters of your common knowledge and your observations and experience in the affairs of life. It is the duty of the jury to scrutinize and to weigh the testimony of the witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability of the witnesses and of the weight to be given to their testimony. In determining the credibility of each witness and the weight you give to the testimony of each witness, consider these factors: whether the witness has an interest or lack of interest in the results of the trial, the witness's conduct, appearance, and demeanor on the witness stand, the clearness or lack of clearness of the witness's recollections, the opportunity the witness had for observing and for knowing the matters the witness testified about, the reasonableness of the witness's testimony, the apparent intelligence of the witness, bias or prejudice, if any has been shown, possible motives for falsifying testimony, and all other facts and circumstances during the trial which tend either to support or to discredit the testimony. Then give to the testimony of each witness the weight you believe it should receive. There's no magic way for you to evaluate your testimony. Instead, you should use your common sense and experience. In everyday life, you determine for yourselves the reliability of things people say to you. You should do the same thing here. Ordinarily, witnesses may testify only about facts. However, a witness with expertise in a particular field may give an opinion in that field. In determining the weight to give to this opinion, you should consider the qualifications and credibility of the witness, the facts upon which the opinion is based, and the reasons given for the opinion. Opinion evidence was received to help you reach a conclusion. However, you are not bound by any expert's opinion. The defendant in the criminal case has the absolute constitutional right not to testify. The defendant's decision not to testify must not be considered by you in any way and must not influence your verdict in any manner. In reaching your verdict, examine the evidence with care and caution, act with judgment, reason, and prudence. Defendants are not required to prove their innocence. The law presumes every person charged with the commission of an offense to be innocent. This presumption requires a finding of not guilty unless, in your deliberations, you find it is overcome by evidence which satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you can return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with the defendant's innocence, you should do so and return a verdict of not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which reason can be given arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based on mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. While it's your duty to give the defendant the benefit of every reasonable doubt, you're not to search for doubt. You're to search for the truth. Burglary is defined in Section 941.10 of the Criminal Code of Wisconsin. Is committed by one who intentionally enters a building without the consent of the person in lawful possession and with intent to steal. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following four elements were present. Number one, the defendant intentionally entered the building. Number two, the defendant entered the building without the consent of the person in lawful possession. Number three, the defendant knew that the entry was without consent. Number four, the defendant entered the building with intent to steal. Intent to steal requires that the defendant had the mental purpose to take and carry away the movable property of another without the consent and without consent, and that the defendant intended to deprive the owner permanently of the possession of the property. It requires that the defendant knew the property belonged to another and knew the person did not consent to the taking of the property. The intent to steal must be formed before entry is made. The intent to steal, which is an essential element of burglary is no more or less than the mental purpose to steal formed at any time before the entry, which continued to exist at the time of entry. You cannot look into a person's mind to find intent and knowledge. Intent and knowledge must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent and knowledge. If you're satisfied beyond a reasonable doubt that all four elements of this offense have been proved, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. The information alleges not only that the defendant committed the crime of burglary, but also that the defendant armed himself with a dangerous weapon while in the enclosure. If you find the defendant guilty, you must answer the following question, yes or no. Did the defendant arm himself with a dangerous weapon while in the enclosure? Dangerous weapon means an item that can inflict death or great bodily injury. Armed means that the defendant knowingly took physical control of a dangerous weapon. Enclosure means a building or room where the burglary was committed. If you are satisfied beyond a reasonable doubt that the defendant committed the crime of burglary and that the defendant armed himself with a dangerous weapon while in the enclosure, you should answer the question yes. If you are not so satisfied, you must answer the question no. Theft, as defined in section 943.20 sub 1 sub A of the Criminal Code of Wisconsin, is committed by one who intentionally takes and carries away, uses, transfers, conceals, retains possession of movable property of another without consent and with intent to deprive the owner permanently of the possession of the property. Before you can find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following four elements were present. Number one, the defendant intentionally took and carried away movable property of another. The term intentionally means that the defendant must have had the mental purpose to take and carry away the property. Movable property means property whose physical location can be changed. Two, the owner of the property did not consent to the taking and carrying away of the property. Three, the defendant knew that the owner did not consent. Four, the defendant intended to deprive the owner permanently of the possession of the property. You cannot look into a person's mind to find knowledge and intent. Knowledge and intent must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon knowledge and intent. If you're satisfied beyond a reasonable doubt that all four elements of theft have been proved, you should find the defendant guilty. If you're not so satisfied, you must find the defendant not guilty. If you find the defendant guilty, you must answer the following question. Was the property taken a firearm? Firearm means a weapon that acts by force of gunpowder. Before you may answer the question yes, you must be satisfied beyond a reasonable doubt that the answer to the question is yes. If you're not so satisfied, you must answer the question no. And those questions will be on the same verdict form, and you'll find them in the packet. Possession of burglarious tools, as defined in section 943.12 of the Criminal Code of Wisconsin, is committed by one who is in personal possession of any device or instrumentality intended, designed, or adopted for use in breaking into any depository designed for safekeeping of any valuables or to any building or room, with intent to use such device or instrumentality to break into the depository, building, or room and steal therefrom. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. Number one, the defendant had possession of a tool or device. Possession means the defendant knowingly had actual physical control of a tool or device. Two, the tool or device was suitable for use in breaking into a building. This may include common and special tools and devices. 3. The defendant intended to use a tool or device to break into a building or with intent to steal. This means that the defendant must have possessed the tool or device for the purpose of using it to break into a building with the intent of taking and carry away movable property of another without consent and with intent to deprive the owner permanently of the possession of such property. You cannot look into a person's mind to find intent and knowledge. Intent and knowledge must be found, if found at all, from all the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon knowledge. If you're satisfied beyond a reasonable doubt that all three elements of this offense have been proved, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty.